want to thank Karin for her presentation. As always, it's very informative. I took some notes. I got to get some of those publications. I'm built just like most of you guys. I'm very creative. So about 80% of the stuff I think to do within my IRA usually isn't allowed. But at least I haven't done anything wrong. I just have to go and see what I can do. Our last speaker today, and then again we're going to have the panel so we can have questions after this, is Teresa Rhyne. Teresa owns a Teresa Rhyne Law Group, and she's brand new to our group. Aaron and I met with her, and we were trying to understand basically how to give away your assets and still get the cash flow. And to be honest with you, I can't think of what that's called off the top of my head, but she'll tell you in a few minutes. There's all kinds of, here we are first we're trying to make it, then we're trying to have the IRS not take it all on an annual basis, then we're trying to invest it to where they don't take it while we do that, and then we finally end up with a pile, and we'd like them not to have it at the end of our life either. And there's a lot of ways that we can do things, but most of it has to do with planning ahead. And so, Teresa, welcome. Look forward to this.
It is afternoon, so good afternoon. You can all hear me fine? Great. You are all really to be commended for sticking around. Not only there's been such good information, but I thought for sure with a gorgeous day like this and in this gorgeous place that no one would end up staying to hear the death and taxes part of it. So thank you for staying. The way you can tell that I'm the attorney on the panel is I'm the only one who doesn't have a pretty PowerPoint presentation for you. I'm the one who has the thick stack of documents for you. So if you pick that up, because everybody thinks lawyers get paid by the page, so here's proof. It's also because I'm, as Bruce pointed out, the new guy, so I didn't realize how fancy in the PowerPoint. So next time I'll have fun slides or something. Fun slides about death and taxes. Let's all think about that for a second. But really, that is one of the things I wanted to mention too. A lot of people, when they hear estate planning, that's what they think of. They think of death and taxes. And at best, they think that's a will and a trust, and I get that done once, and I stick it in a drawer, and I never have to think about it again. And that's true if between the time you stick it in the drawer and the time you die, nothing in your family changes, and no laws change. So maybe for somebody that's a true statement, but for most people that's not true. Estate planning is sort of a living, breathing thing that you need to continue to think about, and particularly if your estate is the size of one that might be taxed in the future. And I say might be taxed in the future because I think we're probably all aware at this point that the estate tax laws have changed just dramatically over the last 10 and 15 years. There was a time, oh, it's cute, there's a wedding going on. The couple is coming right down the aisle as we're talking. As I'm talking about death and taxes, the happy couple is... I hope the speaker goes outside. That would just wait till I get to the premarital agreement part. Lost my thought there. Anyway, the estate planning is something that needs to look at because the tax laws have changed so dramatically. When I first started doing this, I think the exemption was like 600,000, maybe even less than that. For estate tax, any estate over 600,000 was going to be subject to estate tax. It went to $1 million, it went to $2 million, it went to $3.5 million, and then it went away completely for that one lucky year. And now it's at $5,250,000. That's what the estate tax exemption is currently. Anybody can die and leave $5,250,000 to anybody they want, and it won't be subject to estate tax. Okay, that was the one part of taxpayer relief in the Taxpayer Relief Act, is the $5,250,000, which was a much bigger number than what we had been seeing or hearing, or it could have been. But, as I think you saw earlier in Matt and Amanda's presentation, they also bumped up the estate tax rate from the 35% to the 40%. So if you are over the $5,250,000 for one individual, your estate's going to be taxed at 40%. So while getting a will and a trust in place and powers of attorney and that sort of thing is certainly the very beginning good basis starting point for estate planning, There is another level of it, which is estate tax planning. Although I am not a huge fan of letting the tax tail wag the dog. So I never like to see things that are done purely for tax planning purposes. They usually don't end up making sense, and they don't end up making people happy. Unless you're one of those people, and I certainly have those clients who do not want to pay taxes no matter what, and will do anything, including give all their money away, just so they don't have to pay taxes on it. That's fine. But usually there's some other reasons for doing some of this planning as well. And the one thing I do also want to make a point of, the very, very best estate tax plan, if that's all you were doing, was planning for taxes, is to just use up absolutely everything you have, spend it or give it away, and die 5 minutes after you use your last penny. It's a very hard plan to enact. There are a lot of risks involved in this. It's perfect if you can do it, but very few people can. But we can get close. And that's kind of what I wanted to talk to you about today a little bit, some options that you have. Whether it's because you want to reduce your estate taxes, and for a married couple, that means $10.5 million can be passed without being subject to estate tax. But it may be that you're not worried about estate tax, but you are worried about taking care of the next generation or the next generation below that. You want to do some of this income shifting that was talked about earlier on a larger scale, whether that's to reduce your estate or just to help them out. There are some things that can be done without having to pay taxes on it. I'm now at that age where I can see you fine, but I can't see a thing that's on my paper here. And if I do this, I have no idea any of you are out there or that there's a wedding going on. So if you're raising your hand or giving me I won't see you at this point. So I'm not ignoring you. You can just, this way I also can't see you all going when I start to talk about estate taxes and taxes. But what I want to do is start with a couple of key concepts for you to keep in mind. Bruce kind of touched on it a little bit with the concept that people want to give things away because they don't want them taxed, but the last thing they want to give away is control, particularly if what we're talking about is giving it away to your kids, right? Groaning is going on. Either because your kids are young or because they're not mature enough, or you don't like, sorry couple, who they just married, or whatever the reason is. That's a very common sentiment is, I want to do it, but I still want to control things. Well, basically, if you can control it, you can touch it, so can the IRS. And so can your creditors. So there are some limits. So it's a lot of the estate tax planning and the gift tax planning that we're talking about is walking that line between what you can be comfortable with and what the IRS can sort of be comfortable with. Just getting that perfect sweet spot where you have enough control that you're comfortable, but it's not going to be included in your estate at the time of your death. So that's a little bit what we're talking about. There's always a give and take. But think of it this way, if you've moved it out of your control enough to where the IRS can't get it, typically your creditors can't get it either. And that can be a creditor from a lawsuit, that can be a creditor from a divorce. I'm very conscientious of this poor couple out there while I do this. Any of those types of creditors that can come along, yours or your children's or things like that. So the good side of letting go of the control a little bit is you can prevent creditors besides just the IRS as well. So some other concepts to keep in mind before we start to get into the types of strategies you might want to use. As I mentioned, the estate tax, it's actually annoying to not be able to see you. The estate tax exemption now is the $5,250,000. That is will be indexed for inflation. The IRS's view of inflation, so you can expect the number to go a little bit more slowly, but that's where it is right now. So at your death, like I said, $5,250,000 to as many people, to whoever you want, doesn't matter, it's not going to be subject to estate tax. You can also give away during your lifetime $5,250,000 without it being subject to gift tax. But it's the same $5,250,000. You don't get to give away $5,250,000 now and then die and give away another $5,250,000. It'll balance out. But obviously, you're all familiar with the concept of leverage, so giving it away earlier can really get a lot more of it out of your estate because the appreciation of what you give away is over with whoever you've given it to, not sitting growing in your estate. In addition, there is an annual gift tax exclusion of $14,000. Right now it's $14,000. That also will continue to grow really, really in tiny amounts. It was 13,000 last year, and a little before that was 12, and it's barely inching up. But for right now, it's $14,000. You can give $14,000 to as many people as you want. You can go well over $5,250,000 if you're doing it in $14,000 increments to 1,000, 2,000 people. Please include me on the list. Just saying. You can do that, and it won't cut into your $5,250,000 number. And so that leveraging that $14,000 becomes important in the planning as well. So that's the law today. Those are the exemptions today. Those things have changed all over the place. The other people who were a little bit relieved with the Taxpayer Relief Act were estate planning attorneys, because before we had this sort of moving scale of what was going to be exempt and what might be exempt, and there were all kinds of different bills pending on what was going to happen. It was incredibly difficult to try and explain it to clients and do any kind of planning. At least now we have a law in place that, for all intents and purposes, is permanent until Congress changes it. But right now, at least, we know what the law is. I and most planners expect that it's going to change again at some point in time. It's just one of those things that constantly gets battled about in Congress, although apparently they've had other things to deal with lately. So that one hasn't come up a lot. So let's talk about some strategies now. I mentioned leveraging the gift before. Leveraging the gift is moving assets outside your estate, outside what will be considered part of your estate and taxable, getting the most advantage out of that you possibly can with the least reduction in those available exemptions. You can use up the $14,000 all you want, because once the year is gone, you don't get to use, that year's gone. Then you're on to the next year, and you got another $14,000 to do. So you want to tend to build on those and do it as frequently as possible. But there's a way to leverage those gifts, which involves discounting the gifts. If I give you $100,000, you're going to be very happy, but it's a gift of $100,000. No question about it. It's cash. We all know what the value of cash is. It's $100,000. So I've used up $100,000 of my exemption. But if I give you a 10% interest in an LLC that I've formed, and I put $1 million into this LLC, and I give you 10% of that LLC. Have I given you a gift of $100,000? Maybe, maybe not. Probably not, because if I'm giving you that 10% interest, that LLC operating agreement probably says I'm going to stay the manager. You don't get any say-so over it. It also probably says if you give that 10% away, I get the first right to buy it back, and here's the price I get to buy it back. It says you can't transfer it at your death. It says all kinds of things that limit what you can do with that 10%. So while I have, in fact, moved $100,000 of value out of my estate because I gave you 10% of that LLC, the value of that gift for gift tax purposes isn't going to be $100,000. It's going to be discounted for those restrictions on it. Typical discounts are for a lack of marketability. I gave you something you can't turn around and sell, so it's not really worth $100,000 to you. And a lack of control. I gave you something that all you can do is hold. You don't get any say-so over what that LLC is doing, so there's another discount built in there. Typically, and it depends on the terms of the operating agreement, depends on who's getting it, how much has been given, but typically those discounts can get up to 30 to 40%. So rather than having given you a gift of $100,000, I've given you a gift of $60,000 or $70,000 of value as far as my gift tax return. So I've moved $100,000 of assets out of my estate, I've kept control, yay, and I've only used up $60,000 of my lifetime exemption. Now, maybe part of that was $14,000 of the annual exemption. And then the rest of it, quick, somebody do that math for me, $44,000, right? The other $44,000 I used of the lifetime gift exemption. So that's the concept we're talking about in leveraging, is what I'm giving you, what I'm getting out of my estate, and what I'm giving you might actually be two different things. I've moved $100,000 out of my estate, the value, by putting that property in the LLC, and then chipping away a piece and giving it to you. but I've only used $60,000 of my gift tax exemption. So that's the kind of leverage we're talking about. And there are different ways of doing that, different strategies for doing that. And as always, again, it's a matter of finding the balance. You want to give away your assets, but you want to keep control. Maybe that's only true for a certain period of time, and then eventually you don't want to be in control anymore. You want that to transition as well, and there are ways to do those sorts of things. And why would you do that? You would do that to reduce estate taxes. You would do that to reduce income taxes. That 10% that was given away, if that LLC has income that's reported through to the members of the LLC, whoever you gave that 10% to is going to get 10% of the income that comes through, and they're going to pay tax on it, not you. So maybe it's 20% and then 30%. You're going to get that income moving over as well. When you're in the income building, wealth building stages, that's a difficult concept because you want all the income, but there comes a point in time when you don't anymore. You're fine, and all it is a tax problem to you, and you want to help the next generation or 2 generations down. That's one of the ways of moving it. You're moving it out of your estate, you're moving some of the income stream over to the other generations, and you're using up very effectively your gift tax by letting the appreciation of that asset sit over here with the other generation, or at least in part. So let's talk about some options using that. Obviously, I gave you one example there of just doing it through an LLC, which is done quite frequently with real estate investments. A lot of people use LLCs for real estate investments anyway, for the asset protection purpose as well. So let's talk about first options to benefit you and your non-charitable beneficiaries. Now, you may think your kids are charities, and they may act like it, but they are non-charitable beneficiaries, so it's a slightly different plan here. One of the ways of doing it is whatever it is that you're going to be gifting, whether it's cash, whether it's property, whether it's an interest in a business, you may want to do it for all the purposes we just talked about, but you're a little concerned about what the kids are going to do with it when they get it, particularly if it's cash. Or maybe the kids are just too young. You don't want to give a 12-year-old that kind of cash. You want it to be there for them when they go to college. You want to be setting things aside for them. You want to help out, but you don't want them managing it. So one of the ways of doing that is setting up an irrevocable trust for the kids. So you set up a trust. You may have your own living trust in place. That's a different trust. Then you set up an irrevocable trust that is for the benefit of your children and maybe even your grandchildren. It has a trustee, which is not you. If you're the trustee, you're going to be in control of it, so it's going to come right back over to your estate. But maybe you do have at least one responsible child, right? You set that one responsible child up as the trustee, or you have one child who's really involved in the family business or really involved in the real estate with you or whatever it is you're going to do. That child can be the trustee for the benefit of everybody else. Or it can be your brother, or it can be someone you trust, or it can be a professional trustee. You set up that trust and you gift into that trust whatever it is that you've decided you're going to give away. Cash, not as much leveraging with cash. It's going to be dollar for dollar. Or property. There might be a little bit of leveraging with property, depending on what the restrictions are on how they can transfer it. An interest in a business. You're going to really have leveraged it, plus, and it's going to sit in the irrevocable trust with somebody else managing it. So those are some simple things that can be done to deal with this issue of control. You can gift it straight out to your kids. That's fine. That runs without an irrevocable trust. That runs the risk of their creditors attaching it. That runs the risk of them wanting out, that there's a little more family strife built into it. So an irrevocable trust is something that can really help with that. Another option is, as I talked about, you can gift the LLC interests. So you set up the LLC, transfer the property into it or whatever the item is that you're going to be gifting, and then you gift the LLC interest to the children. We see this a lot because typically the operating agreement says mom and dad are the managers, so you're not going to have any say-so over it, but you're going to have this income stream coming through. And again, we've leveraged our gift tax exemption. The best of all worlds, okay, especially for the lawyers drafting all these documents, but it also works great for the client, is if you're putting it into an LLC and then transferring, or some sort of business entity, and then transferring the percentage of the entity into an irrevocable trust for the children. Now you've sort of got a belt and suspenders approach. You've got the income stream coming out of the business entity, and it's going over to the irrevocable trust, and it may or may not ever come out of that trust. Well, eventually it will, but to the children. It can sit there as long as you need it to, when the trustee will be in control and can make those distributions as they need. It is also asset protection. It's belts and suspenders again for asset protection as well, because your kids' creditors cannot get through to the irrevocable trust to get to those assets, because that irrevocable trust doesn't belong to the kids. It's not theirs. It's not their asset. They're merely a beneficiary of this, so their creditors can't reach it. That includes future ex-spouses. That one took a little while. That's planning, yes. But if your children are young, you don't know who they're going to marry, so you don't know if they're going to have, or sometimes they're already married and you know that there's a future ex-spouse on the horizon. So it takes care of those sorts of creditors as well. So like I said, you get the asset protection because it's a trust, and then it's an LLC on top of it so it's many layers protecting that asset and protecting the other family members from it. So that's kind of a best of all worlds. The irrevocable trust can be set up to continue for generations and generations if done properly, because in addition to the estate tax, there is what's known as a generation skipping tax, which is just what it sounds like. Were you to pass away and leave all of your estate to your grandchildren, the IRS might be upset because they look forward to being able to tax when you die, and then when your child dies, and then when that child dies, and so on. They want to tax it every generation. So if you skip a generation, they get annoyed with you, and they will impose a tax, a generation skipping tax, that is as though it went to both generations. But there is an exemption for that as well. And that exemption happens to be the same as the other dollar amount we've been talking about. But you have to be aware of it, and you have to be careful to use it and use it in your planning. So if you set up this irrevocable trust for your kids, and you were eventually transferring over this $5.25 million or whatever it was you transferred over, and that trust said, keep it in trust for the lifetime of my kids, or maybe it says, keep it in trust for the lifetime of my descendants. Descendants includes more than kids. Now we're talking grandkids, great-grandkids. That's a generation skip. So, but it might be a good thing. You can have it there. It can be available for everybody who needs it. And if that $5 million that you transferred over grows to $15 million, it's not subject to estate tax in your estate or anybody else's. There is a crazy rule against perpetuities in California that lets that trust only go on for some very complicated formula that's basically 90 years after the death of the youngest person when you die. No one understands it. I don't know how they enforce it, but at any rate, in theory, this trust could go on for a very long time. I'm wondering who's doing that math. Which IRS agent is around 90 years after the death of the newborn when the great-grandfather passed away, but the rule does exist. So you can set aside this irrevocable trust, and like I said, keep it protected from creditors, keep it there for many generations to come. And the income stream is also controlled. Now, the trust is going to have to pay tax on the income if it doesn't distribute it, so that somebody's going to have to pay tax on that income. But that might be a good trade-off. That might be a little insurance there. The trust is going to hold the money so that nobody does anything irresponsible with it, or the trust is going to distribute it, but they're going to distribute it appropriately to beneficiaries that are doing good things with it. So a lot of advantages to doing it that way. If you do that, if it's anything other than cash, those sorts of gifts, an appraisal is needed, and a real appraisal. I can't emphasize that enough. The IRS is not fond of this technique. It's perfectly legal, but the IRS is not fond of this technique because people get a little too creative with it. So if you're gifting, particularly if you're using the discounts that we talked about, it does need to be appraised. The LLC interest, and let's use the example of you put real estate into an LLC and then you gifted the 10% of the LLC into an irrevocable trust. The appraisal is two levels. There's an appraisal of the real estate, and then there's an appraisal of the LLC interest itself. You would think those numbers would be the same, but they're not. The appraisal of the LLC is where the discounts come in. Because the real estate, we know what that's worth. It's worth $1 million, right? You have a real estate appraisal. But what's a 10% interest in the LLC that owns that worth? Well, now we have to look at the operating agreement of the LLC and see what the restrictions are, and that's where the discounts come in. So the downside to doing it, at least in the setup period, is there's expense. There's the legal expense of setting it up, there's the appraisal expense, and there's the gift tax return that has to be filed. But you can end up saving an awful lot of taxes that will more than equal what you've spent on. Easy for me to say, right? Frequently, and this is why the last quarter of the year is my busiest quarter in my law office, I have a lot of clients who are high net worth and don't do their will and trust and stick it in a drawer and never see me again. We work every other year together. And you may wonder why every other year. So I will tell you why every other year. Because they do this kind of gifting. So typically what is done is the appraisals are done around December. And we do a gift in December, and then we do a gift in January so that we can use this year's $14,000 per kid and next year's $14,000 per kid with one appraisal. That's because it's close enough in time. Otherwise, we'd have to do an appraisal every year. And nobody likes spending that kind of money. So I end up seeing one set of clients for this December, January gifting, and then next December, January, it's another set of clients because we're rotating. It'd be really cool if I could keep those balanced and have, nope, you can't do it this year, you have to wait till next year. But I can't. And I like seeing the clients anyway. But that's why we're very busy. I start in the summer saying, are we going to do it this year? Can we start working on the appraisals and talking about what we're going to get done? But everybody ends up coming in October, November, and December to get it done. But it works. And but you do need the appraisal. So I want to emphasize that for many reasons. The appraisals are where the discounts come in. That's important to you. The control, I think I mentioned this, the control is because you stay the manager of the LLC. There is a trustee involved on the trust that is not you, but what that trustee isn't involved in the business. They're just taking the income and deciding what to distribute according to the terms that you've set out in the trust. You can be as specific as you want in the trust as to what distributions can be made and when and how and what for. I have some clients who go the very basic, it's for health, education, support, and maintenance of my descendants. Very simple. I have other clients who have pages and pages and pages and pages, which is great, that's wonderful for the trustee, that say, you can give X amount of dollars for a first wedding. No one leaves it for a second or a third wedding. And this is California. Or they'll say, for college education, but no longer than 5 years. Used to be 4, now it's 5. Or they'll say, for travel, that it's good for travel or for family vacations or things like that. You can be as specific as you want to be. You're giving those directions to the trustee, so in a way, you're still controlling things. But the trustee is going to carry it out. The important part is you're still the manager of the LLC or whatever the business entity is, so you still have that control over those investment decisions and business decisions, which is, I think, what most people are interested in as well. Okay, I also need to mention one thing. What makes it a gift? If you do all that and your kids really can't get to it, what makes it a gift? There is this other funny little quirk where if you're using up that $5,250,000 lifetime gift exemption, it's a gift no matter what, because you could use it now, you could use it then, so it's a gift. But if you are using that $14,000 a year, and there's no reason not to use that $14,000 a year when you're doing this leverage, especially if you have lots of kids and grandkids, you can get a big chunk passed through by using that exemption. But if your kid never really has a chance to benefit from that gift because it's an LLC interest that's been put in an irrevocable trust and they can't touch it or get any distribution, the IRS says that's not a gift. So there was a case out there and one of the great ironies, of course, the taxpayer's last name was Crummy. So the crummy law that came to be, because the taxpayer won, what they did was they gave notice to the beneficiaries that this gift has been made into this irrevocable trust. There's $14,000 sitting, or back then it was something like $8,000 sitting there. You have 30 days to withdraw it. If you don't withdraw it, you can't touch it anymore. And it stayed. Obviously, there can be no plan, there can be no written agreement, anything like that, but the kids need to understand that they're not to withdraw that, but they have to have the right to withdraw it. So if they have the right to withdraw it for 30 days, that's what makes it a gift. So it's what's become known as a crummy letter. So it's great joy to be able to tell my clients, and now we need to send your children a crummy letter. We're kind of paying you a lot of money. Don't you think you could write a good letter? Nope, it wasn't the good family that won this case. It was the crummy family that won this case. So that's what makes it a gift. But again, it's an important part of setting up this plan. And it has to be done if you're using up that annual exemption amount, that $14,000 amount, you've got to send notices to and give them a chance to withdraw the funds. Okay, and that's kind of the basic concept for non-charitable. There's variations on a theme. And let me do I should have done at the beginning, kind of a lawyer am I, the disclaimer here. All of these things that we're talking about are very, very fact-specific. So I'm trying to give you the general concepts, but really results will vary depending on your own individual tax and family and factual circumstances. So you do want to get specific legal and accounting advice. You want to talk to both your accountant and your lawyer, preferably at the same time, together, a team working on this to do any of these types of strategies. They can work great. They can also go horribly wrong if you haven't put all the right pieces together. So that's the idea behind gifting and reducing your estate and or taking care of the next beneficiary. Really, 10 minutes?
You can go a little longer.
Okay, I'll rattle through the charitable giving. No. Okay. I was looking for you back there.
Sorry.
Okay, so let's talk about charitable giving now. Charitable giving, you can use a lot of these same concepts, only now, obviously, you're giving it to a charity. A lot of you are probably already doing charitable giving, whether it's to your church or to your colleges, whatever it might be. A lot of you are probably already doing it. This is a way of leveraging that. It's also a way of saving some estate taxes. It's the same sort of concept of moving things out of your estate while still keeping some benefit for yourself. A little bit more restrictive than when you're doing it with family members. Simplest, a charitable gift annuity. A charitable gift annuity is a contract between the donor and the charity. The donor transfers cash or appreciated property. Great if you'd rather not have the gain yourself. You transfer the appreciated property to the charity. Charity makes an unsecured promise to pay an annuity back to the donor. Payments are annually, quarterly, monthly, whatever you want them to be, as long as they're at least annually. Notice I said unsecured. So you're making a gift to the charity, and they're promising to pay you back. The good news is not every charity can do this. They have to be licensed. So there's a little bit of security in the comfort sense, not the legal sense, to doing it. What are the advantages? You get a current year deduction based on the present value calculation. So you've given a gift away, but again, if you've given $500,000, but you've said, only you have to pay me back 5% every year for the next 10 years, well, that's not a $500,000 gift. So there's a present value calculation that gets done, but you get a good-sized deduction anyway, and then you have this income stream that comes back to you over time. Depending on the charity that you're working with, what that income stream is, you can determine between yourself and the charity. Obviously, they're not going to promise you like 20% return or anything like that. There are limits. And the time frame as well, you can determine with them. So you get that deduction. When you get the annuity payment back to you, it's taxed in 3 different tiers depending on what it was you transferred. This is why you need to talk to your accountant. Some of it will be capital gain, some of it will be ordinary income, and some of it will be return of investment. But you'll have spread that out over however many years you chose on this annuity. It's a great way of dealing with if you get a large influx of money at year end and you suddenly need a deduction, or you want to spread out, like I said, the gain on an appreciated property over time rather than taking it all in at one year. This is probably the simplest form of a charitable gift. Very little accounting needed. Set up quickly, easily with a charity as long as they're properly licensed to do it. And the low interest rates currently that the IRS assumes makes it a good time to do it. So, I'll show you that in one of my charts in a little bit, how that works out. The other great advantage to a lot of this charitable giving, and I'll give you a great example for it, is it also can be an asset protection plan. I have a client who, her husband unbeknownst to her, did not pay taxes for something like 8 years. Prepared all of the returns, had her sign all of the returns, and then filed them in the garage. At the same time, he made a large donation to their church and took a charitable gift annuity, and so had a guaranteed income stream back to he and his wife for their lifetime. He then died of a heart attack, no doubt over the stress of knowing what he had done with these tax returns, because when they found the tax returns in the garage, they also found a whole bunch of notices from the IRS with delinquent taxes, and the IRS will eventually file your tax return for you based on all the information they have for your income. So that was happening to him, and he died. Widow knew nothing about this, so we were in a discussion with the IRS about this. Well, it turned out all that was left for this woman was this charitable annuity. It was a relatively large charitable annuity amount, but that was all they had, and then this huge tax bill. We were able to get an offer in compromise for her because the charitable gift annuity didn't belong to her. The income stream would, so all they could do is attach the income stream for the statute of limitations period. And that was it. But she needed that income stream for her life, for her living expenses. So whether the husband knew that's what he was doing and had set her up like that, I don't know. I will tell you that if you did that plan intentionally, they'd probably come after you for tax fraud, but he had died, and she knew nothing about it. So my point is only, I learned really in the best and worst possible way that charitable gift annuities are really exempt from your creditors. So you can move something over and you've got this guaranteed income stream as long as the charity exists and has the money to pay it, and your creditors can't reach it. The same is true of the next things that we're going to talk about as well. So probably one of the most common we hear, as I put on here, they just happen to sound like chicken noises, are the crats, cruts, clats, and cluts. See, they do sound like chicken noises. A CRAT is a charitable remainder annuity trust, very similar to the annuity gift I just told you about, except rather than just directly handing the money over to the charity, you're handing it to a charitable trust. You set up the charitable trust, you set up the terms of it, you transfer the asset over. The trust then has made a promise to return the money to you. When it's a CRAT, the annuity trust, it's 5% of the value when the trust is first formed. So you'll see in the example I gave you, the first example, I gave you an example of a gift of $1 million. It doesn't have to be $1 million. That's just a fun number to do. Gift of $1 million, and you say to the trust terms are, I'm going to give you $1 million. You're going to pay me back 5% of that at the end of each year for 20 years. So you're going to get $50,000 a year. It's always going to be $50,000 no matter what happens to the trust unless it loses all of the money. $50,000 a year for 20 years. You can see on the chart one, that would get you an immediate deduction of $213,130. Now that may not sound like a huge deduction for $1 million gift, but if you look at the next page, it's showing you what the payment is that you're going to receive. So you're going to receive the $50,000 over 20 years. So you're actually going to get that $1 million back. You're not going to get earnings on it, but you're going to get that $1 million back. And you have a deduction of $213,000. Obviously, there has to be some charitable intent here because those numbers don't work out perfectly. You'd think, I could earn more than that on the $1 million. It's not worth doing it. That would probably be true. There does need to be some charitable intent here. What I did in this example was I assumed that the trust itself, the $1 million gift, was growing at a rate of 6% annually. You may not consider that an aggressive number. Oddly, the IRS does. The IRS assumes it's going to grow at 2.4%. But if it grows at actually 6%, then at the end of the term, the 20 years, there's going to be a gift of what's left in that trust. The charitable remainder is now going to the charities that you've named. Could be one charity, could be more than one charity. You could reserve the right to name the charities at the end of the term. And they'd be getting about a little less than 1.4 million. So not a bad tool. Again, you've got this guaranteed income stream. It's not subject to your creditors. It will be taxed as it comes back out, but again, that's usually a whole lot better to take it in small increments over time than all in one big hit. Plus, you got the big tax deduction at the beginning. A charitable remainder unitrust is exactly what I just said, except rather than 5% of the total when the trust is first funded, it's going to be 5% of the value of the trust each year. So if the trust does really, really well, you're going to get more and more. Your distribution is going to be larger and larger because you're getting 5% of a bigger and bigger pie. So the example that I gave you in 2, we did the $1 million, I still assumed the 6% growth, and we said you're going to get 5% back. Now you're getting a bigger deduction. Now you're getting $360,796 deduction in that first year. That's because you're taking more of a risk. So the present value calculation is assuming, remember, it's assuming that this trust is only going to grow at 2.4%. So if it's growing at 2.4%, and you're taking out 5% each year, there's your risk this money's going to go away and you're never going to actually get your money back. So they give you a bigger deduction because more, in theory, has gone to the charity. You don't really need to worry about where the calculations come from. It's the little man in the green visor that's in my computer, and then he holds up a sign that tells me that. In other words, it's a software program that has all these present value calculations in it. But just to give you, again, an idea of the concept here. And to show you that it can be a very useful tool, but you do need to have some charitable intent here. But when you add to the fact that you've now moved this out of your estate, you've saved estate tax, you've gotten a charitable deduction, and you've got an income stream coming to you that's protected from your creditors, it's not a bad deal. On the CLUT, I gave you a couple of examples because I wanted to show you that the growth rate, you'll see on example 2B, I put in a growth of 3% but an income of 6%. Didn't change the charitable deduction. It just changes the amount that you're going to get. So in a sense, you're betting against the house. The house is the IRS. They've said right now this month, 2.4% is what they're going to assume your trust is going to grow at. If you beat that, you beat the house, you're getting a lot more coming out to you, and if you do really well, there'll be a lot more going to the charity as well. The last two, the charitable lead trust, you're probably getting the hang of this now. It's very similar to the charitable remainder, but the roles are switched. Charitable lead trust, you move the asset into a trust, and an income stream is paid out to the charity over a certain number of years, and at the end of that term, you get what's left in the trust comes back to you. Why would you do that? Maybe you have a piece of property, you have something that you want to hang on to, but you don't currently need the income stream from it. So you move it over there and you give the income stream to the charity, and then you still get the property back and perhaps greatly increased in value. Same concept there. There's the annuity version of it where what the charity's getting is the same amount every year, and there's the unitrust version of it where they're getting 5% or whatever the percentage is of the value of the trust every year. And the unitrust one, a little bit more expensive. More to gain also means a little bit more expensive because the trust has to be valued every year. Otherwise, how do you know 5% of what? You have to come up with a valuation every year. That's fine if it's sitting in cash or in a brokerage account or something. It's easy to do. If it's in real estate, it's going to require an appraisal every year. You also need to make sure that whatever you've transferred to the trust has an income stream that can be paid out to meet what the requirement is. If you've said 5% income, that the trust needs to generate 5% income to be able to pay, otherwise they're going to end up having to sell the principal. With an annuity trust, the 5%, the set number, you can't add to it. It's a one-time thing. You put it in 5% of $1 million, $50,000 every year. You can't add any more cash to it. With a unitrust, because we're revaluing it every year, you can add more things to it every year. So a little bit more flexibility in it, a little more upside in it, also a little more downside because of the valuation. I also added on here, went through that very quickly. That's why I give you a big stack of paper so you can study it and look at it. But this was just to get you used to these sorts of concepts anyway. I also put in here, just very quickly, the life insurance trust. Typically, a life insurance trust is used in conjunction with these types of of charitable trust, either the charitable remainder or the charitable life trust, because you are giving something away. There is something going to the charity. The good news is it's out of your estate. The bad news is it's out of your kids' hands too, right? As far as your kids are concerned, that's the bad news because the charity got it. So a life insurance trust is used in conjunction with it to sort of replace that income. You set up a life insurance trust. You make the gifts, the $14,000 a year, cash, whatever it is that you're, whichever exemption you're going to use, into this trust. Your kid or someone else is the trustee of this trust. They send out those crummy notices. Nobody takes the money out. The money is then used to pay the premiums on a life insurance policy. At your death, it's typically, if it's a married couple, it's typically a joint, or it's a last survivor policy. So it's on the two lives, because that's when the estate tax hits. When the second of you passes away, the insurance pays off in the trust. It wasn't in your estate. You didn't own it. You gifted it away. It's not yours. It's not in your estate. So whatever you've set over here will then replace what you gave away to the charity. I think besides my time being up, that was an awful lot of math. So I just want to leave with this caution. The other reason you need to carefully plan for this is because there's a finite amount of exemptions that you can use. So you have to kind of strategize where we're going to use that. If you're going to do the charitable gift, that's great because it's a charitable gift. But if you're going to do life insurance, then we need to know what the premium is going to be, how much of your annual gifting you're using there, versus if you're going to set up the LLC and make some gifts over here. So it's a team effort, but done well, it can really be very beneficial to you and to your heirs. So